us our updates and be part of our conversation squad.
Yeah, Avni, are we live?
Yeah, just 1 minute. Live.
Yeah. Good morning, everybody. Welcome to the Sunday morning Manthan talk. Today, we are honored to have Suhrith Parthasarathy. Suhrith, who many of you may have seen, writes often in the Hindu. He is a lawyer practicing in the Madras High Court. His area of work is public law and taxation. But he is also a public commentator on public issues, and he frequently writes not only in the Hindu, but I would say occasionally in the India Forum as well. Now, Suhrith is not your ordinary lawyer, if I may say so. Besides having a degree in law, he also has a degree in journalism from the most prestigious school of journalism in the world, the Columbia School of Journalism. And before, other than the Hindu, he's also written in, I think, the Caravan and other places. So today, Suhrith is going to talk about the secular court and freedom of religion. The context, of course, is the hijab controversy, but he's going to talk about larger issues about whether the court should be involved in educating on religious practices. Suhrith, the camera is yours. Yeah.
Thank you, Ram. Hello and a very good morning to everyone. It's a great privilege to be speaking to all of you. And I must begin by thanking Mr. M.R. Vikram, Mr. Ram Manohar Reddy, and everyone else at Manthan for this opportunity. The peg, so to speak, on which this talk rests is, as Ram said, the recent judgment of the Karnataka High Court in Resham versus State of Karnataka, in which the court upheld a ban on the use of the hijab by Muslim students in schools and colleges in the state. The proceedings in this case, which was heard by a full bench of the High Court comprising 3 judges, were broadcast across the country on YouTube. Now, this live streaming of the hearing allowed us all to perhaps engage with a litigation of constitutional and public concern in a manner that we've not been used to in the past. Of course, as all of you would be aware, the judgment has since been taken on appeal before the Supreme Court, where it is presently awaiting a hearing. Now, which way the verdict falls there might come to have a deep bearing ultimately on the scope and purport of the right to religious freedom in India. For now, though, in this talk, over the course of the next 40 to 45 minutes or so, I'll try and provide a brief overview of the High Court's judgment in Resham, and we'll try and see how this case fits into the larger story of Indian secularism and how it interacts with established doctrines that have been used by our courts to interpret and explicate the range and influence of liberties predicated on conscience and religious faith. Now, the questions that came up for consideration before the Karnataka High Court in this case were fairly simple. Was there under law a prohibition on the use by Muslim women of hijabs in public spaces, in particular in colleges in the state? Could mandates of a uniform in educational institutions enforced by the government effectively bar the use of the hijab? Must a reasonable accommodation be made to permit women to wear the hijab while otherwise conforming to the uniform that has been mandated? The court did not directly answer these questions. Instead, what it did was that it delivered three findings, which according to it led to the effective conclusion that the hijab could not be accommodated in the classroom or within the precincts of an educational institution. So what are these three findings? First, the court held that the wearing of a hijab is not essential to the practice of Islam, and therefore the petitioner's right to freedom of religion under Article 25 of the Constitution hadn't been violated. Second, the court held that there is, under law, no substantive right to privacy or free speech and free expression that the petitioners were capable of asserting within the confines of a classroom. Third, the court said that this is not a case where the ban that has been imposed seeks to explicitly or otherwise wrought discrimination against Muslim women students, because according to the court, the mandated uniform was facially neutral. Now we'll focus on the first finding predominantly for the purposes of this talk. That is that the wearing of the hijab is not essential to religion and is not essential to the practice of Islam, and therefore that Muslim women cannot, as a matter of right, as a matter of fundamental right, claim the use of such clothing as being guaranteed by the Constitution. Now, to anyone who hasn't studied the history of the Supreme Court's jurisprudence on religious freedom, this finding by the Karnataka High Court might well strike them as an extraordinary conclusion to make. How can a secular court render a ruling on what are really theological creeds and canons? How can a court of law that has seemingly not been vested with any ecclesiastical power render a verdict on the scope of a religious practice? Now, extraordinary as the judgment is on this point, and we see the court going into really long readings of the Quran, despite sort of being quite clearly ill-equipped to interpret a religious text. Now, extraordinary as this judgment is on this point, this is scarcely new for a constitutional court in India. Time and again, we've seen the Supreme Court in particular doing just this, examining whether or not a practice is essential to a religion, and then determining whether or not that practice is protected under the Constitution. Now, why has the court performed this exercise? To answer this question, we must begin with what the text of the Constitution tells us. The text of the Constitution, insofar as the right to religious freedom is concerned, is broadly contained in Articles 25 and 26. Now, although, and I shall come to this later, the position today, at least ostensibly, is that fundamental rights should not be read in silos, and that the rights give and take meaning from each other. That is, that the right to equality contained in Articles 14 to 17 of the Constitution, the right to freedom of expression and assembly, which is contained in Article 19, the right to personal liberty in Article 21, and indeed the right to religious freedom in Article 25 are all inextricably linked, that they form one collective whole. But we'll come to this later. For now, when we see the text of Article 25, we see that it guarantees a right to a freedom of conscience and an equal right, and I stress here on the words equal right, to everyone to freely profess, practice, and propagate religion. Now, this right under Article 25, however, is subject to public order, morality, and health, and also to the guarantee of other fundamental rights. Apart from guaranteeing this right, this provision in Article 25 also does a number of other things. It, for example, expressly protects laws that have been made by the state to regulate any economic, financial, political, or other secular activity associated with religious practice, and also protects laws that provide for social welfare and reforms, including expressly the throwing open of Hindu religious institutions of public character to all classes and sections of Hindus. Now, this is Article 25. Article 26, which isn't particularly relevant from the point of view of the hijab judgment, but is still important from the point of view of religious freedom, deals with group rights. And again, this right is subject to public order, morality, and health, but unlike Article 25, not subject to other fundamental rights. And Article 26 grants to every religious denomination the right, among other things, to establish and maintain institutions for religious and charitable purposes, to manage their own affairs in matters of religion, to own and acquire movable and immovable property, and to administer any such property in accordance with law. Now, these rights that are guaranteed by Articles 25 and 26, when we view them independently, what we see is that they appear to grant a guarantee of complete internal autonomy over matters of religion to individuals and religious institutions. But this, in practice, has scarcely proven true. Courts have tended to protect only those practices which are essential to the religion concerned. Now, to deepen this thesis a little bit, to determine which practices are in fact essential, the Supreme Court has come up with its own sort of doctrinal jurisprudence, which has virtually allowed it, as we saw in the case of Resham versus Karnataka, to sit in theological judgment over religious practices. Now, let's see some examples where the court has done this. And let's take one example. This was with respect to the performance of the Tandava dance by the people belonging to the Anandamargi faith. The court ruled in this case that the performance of the Tandava dance was not an essential tenet of the religious faith of the Anandamargis. And it came to this rather remarkable conclusion, despite the founder of the sect having expressly mandated the performance of the dance in his writings, including in his book, which lays the foundation for the sect's faith. Now, according to the court, those writings provided no separate rationale or justification for the performance of the Tandava dance. And therefore, the court said that it was impossible to conclude that this practice was essential to the Anandamargi's faith. Now, this entrenchment of the doctrine of essential practices meant that courts were effectively determining not only those areas where it was constitutionally justifiable for the state to intervene, but also to determine what kinds of practices were in the first place deserving of constitutional protection. Now, the court was also arriving at these conclusions without, in fact, engaging in any serious fact-finding. It was not conducting any trial for this purpose, but based purely on evidence supplied through affidavits, without any cross-examination on facts. The court was coming to some sort of a conclusion on what practices were essential to a religious faith and which practices were merely incidental or unessential to the practice of a faith. These decisions, therefore, tended to often be rooted, at best, I would say, on personal moral beliefs, and at worst, on pure conjecture. To take another example, in a 1966 judgment of the Supreme Court, Chief Justice Gajendra Gadkar made a series of conclusions on what practices were essential to the followers of the Swaminarayanan sect. Now, he referred selectively to Hindu texts without so much as asking what the conscience of the followers might have in fact dictated. And in one passage, he went on to conclude that the entire genesis of the dispute in that case and the practices that were sought to be agitated as being protected under Article 25 were in fact founded on superstition, ignorance, and a complete misunderstanding, according to him, of the teachings of the Hindu religion. Now, this trend of sort of going on to determine the essential practice of a religion continued for years at end. And we saw the doctrine being applied very famously not so long ago in the case concerning the entry of women aged between 10 and 50 into the precincts of the temple at Shabarimala. The majority judgments in that case dismissed the claims made by a number of interveners who argued in support of the exclusion of women purely by holding that the exclusion was not an essential religious practice. What the court was effectively concluding here was that this practice wasn't conscientiously necessary for the followers of the religion to properly exercise their religious faith and belief. So by doing this, the court was effectively defining for the followers of the religion the true contours, according to it, of what their religious beliefs and practices ought to be. In his separate opinion, however, in the judgment, in his concurring opinion, Justice D.Y. Chandrachud offers a critique of this doctrine, and he tells us about its origins. Why at all did the court start performing this exercise? Now, the term essential religious practice itself possibly owes its existence to Dr. B.R. Ambedkar, the chairperson of the drafting committee of the Indian Constituent Assembly, which was responsible for the making of the Constitution. In a speech which he delivered in the Assembly, Ambedkar said that the religious conceptions in this country, and I'll just quote this, are so vast that they cover every aspect of life from birth to death. So he says, I do not think it is possible to accept a position of that sort, and we ought to hereafter strive to limit the definition of religion in such a manner that we shall not extend beyond beliefs and such rituals as may be connected with ceremonials which are essentially religious. It is not necessary that laws relating to tenancy or laws relating to succession should be governed by religion. Now, Ambedkar's aim here was really to draw a distinction between the religious and the secular, and to argue that the state should be allowed to intervene in matters connected to religion, but not essentially religious by their own nature. And now to that end, in possibly the first judgment of the Supreme Court, in the first case before the Supreme Court, which concerned the exercise of religious freedom in state of Madras, was a Shirur Mutt in 1954. It was using this distinction that was drawn by Dr. Ambedkar that the court sought to distinguish between religious and secular matters, to hold that to determine what constituted an essential aspect of religion, the court ought to look towards the religion concerned and to what its adherents believed was demanded by their religion. So the essential practices test, when it was first conceived in 1954, was effectively a test where the court didn't answer for us what was essential to religion, but rather looked at what the followers of the religion believed to be essential and said that those practices would be protected by Article 25. But since then, the court, perhaps with a view to determining what kinds of circumstances in which the state could legitimately intervene, over time transformed this doctrine into an altogether different form of analysis. Now, in a series of cases, especially through the judgments of Justice Gajendra Gatkar, the Supreme Court came to assume theological authority to study religious scriptures and to determine for us whether a practice which was religious in nature was also essential or integral to that religion. And in performing this exercise, the court ultimately what it did was to conflate tests that were intended for entirely different set of circumstances and conditions. Because this was the court that now was, began to determine not only when the state could legitimately intervene, but it was also determining which practices were deserving of constitutional protection in the first place. But the question now is if this essential practices doctrine is a problem for all these reasons that I've just cited, then what is the alternative? Now, if we were to allow every practice asserted by a practitioner of religion, and if we were to recognize every such assertion as protected by the Constitution, would not the right to religious freedom lead to a situation where the state cannot bring about social welfare and reform? Would the allowing of these practices also not lead to a case where the exercising of religious faith leads to an impingement of other people's individual rights? Now, we know for a fact that all religions are perhaps filled with discriminatory practices of various kinds. And if these practices were enacted in a different sphere of life outside the zone of religion, I'm not sure we would tolerate them. Women who marry outside the Zoroastrian faith are denied entry into fire temples. Menstruating women are forced to stay out of Hindu temples. The Dawoodi Bohra community has a practice through which 7-year-old girls have the hood of their clitoris removed. Hindu temples continue to restrict priesthood to a small community of male Brahmins. Churches do not allow women into positions of power and positions of leadership. So can all of this really be justified in the name of religion and in the guise of an exercise of religious faith? Now, the court's answer to this has all invariably stemmed through the use of the essential practices doctrine to see whether the practice that is claimed to be protected by the right to religious freedom is in fact essential or not. So, for example, under the Hindu faith, to see whether to exclude menstruating women from shrines is necessary or is integral to the practice of that faith. To see, for example, whether the Zoroastrian faith demands that women who marry non-Parsis be denied entry into fire temples. Now, assuming for a moment that the court then finds this practice to be essential, what happens? Do we then tolerate the discrimination? The Canadian jurist and judge Beverly McLaughlin has said that there is really no magic barometer to measure this tension that exists between liberty and equality. And there really is no perfect solution, perhaps, to the conflicts that these sort of disputes generate. But the Supreme Court, in using this essential practices doctrine to solve this conundrum, has achieved at least two things, and neither of those results is especially desirable. It has allowed the court to narrow the extent of constitutional protection that is available to religious performances by directly impinging on the autonomy of groups to decide for themselves what they deem valuable and thereby violating their right to ethical independence. And it has also used this doctrine to negate legislation that might otherwise enhance the cause of social justice by holding that such laws cannot under any circumstances encroach on matters essential to the practice of religion. So, for example, the court struck down a Bombay law that prohibited excommunications made by the Dai of the Dawoodi Bohra community. And the court held that the power to excommunicate is an essential facet of faith, and that in the name of social welfare, you cannot prohibit the exercise of this authority and reform the religion out of its existence. There is, however, in this judgment in Sardar Saifuddin versus State of Bombay, a very interesting dissenting opinion by Chief Justice Dasgupta, which is well worth reading. But that aside, it could be argued that this confusion that this test engenders arises out of the court's failure to genuinely engage with the idea of Indian secularism and how that idea might differ from other accounts. Now, the scholar P.K. Tripathi, who was prolific in the 1950s and 60s, he wrote many years ago about the Constitution's framers and their vision of a secularism that is underpinned in India's own sort of social experience. And this model of secularism, he said, does not call for any hostility towards religion. But at the same time, it also discourages religion or the state from allowing religion to use a kind of power that the state itself perhaps could scarcely exercise. So if we were to give effect to this vision of secularism and allow this vision to come forward and animate our discussions, it is imperative that individual rights be placed in a position of superiority to the guarantee made to groups. That the individual, as Dr. Ambedkar said, is seen as the basic unit on which the Constitution rests. The question to be asked when a claim for protection, therefore, is made under Articles 25 and 26 should not be whether the practice in question is truly or essentially religious, but whether that practice oppresses the rights of individuals and whether its effect is to exclude any member of society by violating their civil rights and by treating them as less equal than other members belonging to the same religion. Now, such a response, I would argue, would maintain a fidelity to the text, history, and vision of the Constitution. And indeed, it is such a response that Justice Chandrachud proposes in his opinion in the Sabarimala case. I have written about this elsewhere, and I won't go into the question in substantial depth here. But let me only summarize the position. What Justice Chandrachud proposed, based on scholarly work, including by the lawyer Gautam Bhatia, is the application of an anti-exclusion principle. Now, this anti-exclusion principle, what it effectively does is to treat any practice which a proponent of a religion or a follower of a religion considers to be essential for his or her own faith as protected under Article 25, but going on to examine whether the power of groups and communities in allowing those practices to continue leads to the exclusion of any person interfering in their freedom to participate in, their normal economic, social, and cultural life as defined in the judgment, and which quotes from scholarly work, as I said, and leads to a disruptance where there is access to basic goods is denied. So even individuals' right to exercise his or her own religious faith and religious freedom is denied by a group based on what that group treats to be essentially religious, then the anti-exclusion principle will kick in and will ensure that the individual's freedom is treated as paramount. Now, the idea on which this anti-exclusion principle is premised stems from the guarantee of equality that is contained in Articles 14 to 17 of the Constitution. Article 14, as we know, speaks of a general right to equality, but Articles 15.1 and 15.2, which are rights against non-discrimination, make it clear that the state cannot and should not discriminate against citizens on grounds of only of religion, race, caste, sex, place of birth. And 15.2, in fact, specifically states that citizens cannot, on grounds only of religion, race, caste, sex, or place of birth, be denied, among other things, access to shops, public restaurants, hotels, and places of public entertainment. And Article 17, as many of us might be aware, is the guarantee against untouchability in any form. Now, the language used in these provisions was each a product of India's history. India's freedom movement was, after all, aimed not only at securing independence by releasing the country's people from the grips of an authoritarian colonial government, but it was also a transformative vision was at the sort of heart of this movement, at enabling a reversing of the historical evils that have plagued the country's communal milieu, specifically the enormous economic and social inequality that has been wrought across generations through the entrenchment of the caste system. Now, it's not by any means novel to suggest that the Constitution ought to be read in a manner which maintains the greatest fidelity to the history of its framing. We've seen deeply animating examples from other jurisdictions, from South Africa very recently. The scholar David Bilchitz has pointed out, for example, pointed to the South African Constitutional Court's judgment in S versus Makwanyane, where the court, in striking down the use of capital punishment, located the right against the use of such punishment to the history and background of the adoption of the Constitution, and read the fundamental rights chapter in the South African Constitution as a whole. Now, I think some of us might see the prohibition that is contained in Article 17 as being restricted to discrimination on the grounds of caste. But the discussions in the Constituent Assembly make it quite clear that when questions were posed about very specifically restricting Article 17 only to caste-based or religion-based discrimination, the Assembly rejected it. Now, a clear demarcation of the prohibition, because the Assembly felt that a clear demarcation of such a kind would ultimately prove limiting. And there's also something to be said about the fact that Article 17 uses the words untouchability in any form. So it was this phraseology that ultimately led to Justice Chandrachud concluding in the Sabarimala judgment that Article 17 must be read widely. Now, of course, as he pointed out, the practice of untouchability may well have its roots in the caste system and the idea of a hierarchical order of purity and pollution, which, as he said, was enforced by social compulsion. But that cannot mean that when the very same notions of purity and pollution are used, for example, to exclude, and this I quote from Justice Chandrachud, to exclude menstruating women from religious places isn't somehow a form of untouchability. So according to him, every manifestation of untouchability without exception lies within the fold of this prohibition that is contained in Article 17. So in the case of the Sabarimala temple, it would cease to matter whether the exclusion of women from the precincts of the shrine is an essential component of faith or not. This is because the exclusion, regardless of its essentiality, would impinge on the individual rights of women, not only to equal status under Articles 14 and 15 and to dignity under Article 21, but also to their own right to practice their religion under Article 25. So when we see things this way, the clash is not merely a conflict between the liberty of one group and the bid for equality of individuals on the other hand, but it is also a clash between the liberty of a group and the liberty of individuals. When conflicts of this kind arise, the Constitution, if we are to read it in its best possible light, must always appeal to a principle of inclusivity, where each member of society is allowed to enjoy equal status and moral parity. So when this model is applied in the Ananda Margi's case, for example, the followers of that faith will be allowed to perform the Tandava dance in public. It would cease to matter whether the practice is essential to their faith or not. Similarly, Jains would be allowed to practice Santara so long as its proponent is voluntarily, that is without coercion, undertaken a fast unto death. But where a practice excludes people from the religious fold on grounds of caste, gender, religion, or other such discriminatory criteria, courts ought to always interfere. Under this model, therefore, a practice that leads to the debarring of women from entering religious places, whether it's a temple, a mosque, or a church, would not be tolerated. Similarly, practices that offend human dignity would, regardless of whether they are essential to religion or not, be struck down. So if this anti-exclusion test is applied properly, not only will we have a doctrine that maintains a fidelity to the Constitution's text and vision, but we will also have a doctrine on hand that effectively consigns the essential practices test to the past. It'll also help us recognize what the scholar Madhavi Sundar has described as a form of cultural dissent, where we don't allow ourselves to subscribe to a singular vision of a community. So how did all of this play out in Resham's case in Karnataka? Now, the court, in considering the question of whether the wearing of a hijab is a legitimate exercise of religious freedom, referred to a number of precedents which pointed to only essential religious practices enjoying constitutional protection, including a number of the case law that we've seen during this talk. The court then said that the petitioners had failed to produce any evidence to show that the use of a hijab was essential to the practice of Islam. Yet, despite coming to this conclusion that the petitioners had failed to produce any evidence, the court still conducted a theological analysis. You would think, that courts of law which do not possess ecclesiastical jurisdiction would be ill-equipped to do so, especially without conducting a proper trial. The court nonetheless came to the conclusion that Islam does not make the wearing of a hijab mandatory. But unlike many other cases where the essential practices test has been invoked, this was not a case where individual rights were competing with the rights of groups. In Shabarimala, for example, where we saw individual women who claimed that their right to religious freedom was impinged by the temple's rule prohibiting women from entering its precincts, was a case where individual rights was potentially at odds with group rights, because other followers of the religion claimed that their right to religious liberty and autonomy would be infracted if women of a menstruating age were allowed in the temple. According to them, the temple's legend and customary practice required the temple to prohibit women aged between 10 and 50 from entering the temple. Now, this meant, at least on the face of it, there were two competing claims that were made, both predicated on religious autonomy and freedom. In Resham's case, though, the only reason for invoking the essential practices test was that it existed on paper. Now, as I said, this is not a case where individual freedom was at odds with group rights. On the contrary, this was a case where exercise of free choice was being curtailed by explicit action by the state. The petitioners before the court had also contended that they were wearing the hijab as a matter of conscience. The text of Article 25 of the Constitution, you may recall, guarantees to all persons not only an equal right to profess, practice, and propagate religion, but also a freedom of conscience. The petitioners' counsel pointed to the Supreme Court's judgment in Bijoy Emanuel's case from 1986, where the rights of Jehovah's Witnesses who had refused to partake in the singing of the national anthem was protected. There, the court ruled that so long as students in a school conscientiously believe that they must not participate in the recital, their rights could be abridged only in the interests of public order, morality, or health. But the Karnataka High Court distinguished Bijoy Emanuel's case on somewhat strange grounds. According to the judgment, there was simply no evidence in this case that the petitioners conscientiously believed in the necessity of the hijab. Now, this is strange because once it is pleaded on affidavit that petitioners were out of a sense of conscience wearing the hijab, ordinary rules of evidence would mandate that the onus would shift onto the state to establish that the petitioners were not in fact wearing the hijab out of a sense of conscience. The court then proceeds to make an even more astonishing assertion. All cases where a right of conscience is pleaded, according to the court, were by their own account cases of religious freedom, that there was no distinction between conscience and the exercise of religious faith. And therefore, even these cases ought to be subject to the test of essentiality. Now, this conclusion, unfortunately, ignores the very specific finding in Bijoy Emanuel's case, where a judgment was delivered based on conscience and where it was found that conscience need not have any direct relationship with religious faith. Now, it is possible, for example, that the hijab might not be essential to Islam, and yet that Muslim women choose to wear it out of an exercise of choice, out of an exercise of their own sense of individual ethical belief. But unfortunately, these are questions that the court simply doesn't grapple with. Now, of course, the argument on Article 25 and the rights to conscience and religious freedom weren't the only ones raised in the case. It was also contended that the petitioner's fundamental rights to free expression and privacy were infringed. We all know that it's not been too long since a 9-judge bench of the Supreme Court, to much acclaim, in Puttaswamy's case, had recognized that the right to privacy is an inherent facet of Articles 19 and 21 of the Constitution. That this right includes within its scope and ambit a right to choice over matters such as clothing, food, marriage, and so on and so forth. Now, that right, once it is recognized, can thereafter only be restricted by reasonable decisions made by the state. And what is reasonable will necessarily have to be judged, the court has held in many recent decisions, on a test of proportionality, by seeing and examining whether there is, one, a legitimate aim and goal of the state at play, seeing whether the measure chosen has a rational nexus with the aim, seeing whether there are less intrusive measures available to achieve the very same aim, and finally seeing whether the right and the limitation are properly balanced, that is, that the right isn't disproportionately affected. But in Resham's case, the court simply doesn't engage in this analysis at all. Instead, the court says that there is no need to dwell on legal doctrine because, according to it, the petitions that the court was dealing with do not involve the right to freedom of speech and expression or the right to privacy at all, to such an extent that it warrants the employment of these tests for evaluation of restrictions in the form of the school's dress code or uniform. The court also sort of draws a rather strange analogy here with prisons and holds that in spaces such as schools and prisons, substantive rights metamorphize into derivative rights. Now, I've read the judgment a few times, but not quite able to gather precisely what the court means by all this. But these derivative rights, according to the court, are incapable of being invoked in protected environments. So in this estual of the proportionality doctrine, in failing to see if other measures are available without affecting the supposed integrity of the school uniform, now it's a different question whether colleges ought to enforce uniforms in the first place at all, although that question ought to have been ideally posed. The court also fails to consider the question of reasonable accommodation. Now, we've seen in Kendriya Vidyalaya schools, for example, that the hijab is allowed within the contours of a prescribed uniform. But the judgment here holds that to make such an accommodation would defeat the very purpose of uniforms. Now, this finding, to my mind, fails to recognize that even within the existing dress code that has been prescribed, many accommodations are already made. Students are allowed to wear religious and cultural marks on their forehead, on accessories, on other parts of the body. All of this is not disallowed. So if the purpose of the uniform is to allow for no differences between the students, surely every exhibition of faith in the classroom must be stamped out. It is therefore that I say that we can only see the failure to provide for a reasonable accommodation for the hijab as a deliberate discrimination that has been wrought on Muslim women. Now, what was also especially striking for me, and I'll conclude soon, is that the idea that colleges ought to somehow represent spaces where identities ought to be hidden, as if the hijab was the only mark of religious identity on show. Whereas in all other secular spaces, it's apparently perfectly fine for people to wear their faith on their sleeves, from courtrooms to legislative assemblies to the parliament. Now, this is to say nothing about the often explicit shows of religion that persons in power express every day. So for the government of Karnataka to say that hijabs ought not to be allowed in colleges, or colleges ought to be allowed to prohibit the hijab, as the government put it, because the college represents a secular space, strikes me as deeply hypocritical. Now, we have pujas to inaugurate court buildings. We have lamps lit during secular functions. The list really is endless. But somehow the hijab, which is worn without violating any other person's right, is a problem. Now, so far, we've seen the confusion that exists at the level of legal doctrine. This confusion has unfortunately only been compounded at the level of the institutional functioning of the Supreme Court. I quite understand that concerns over institutional uprightness might not quite fit in with the topic at hand today. But I think when we discuss matters of doctrine in the abstract, it may not quite be enough. So we must just spend 2 minutes to consider the aftermath of the Sabarimala judgment, and I'll conclude with that. Now, many of us might have profound disagreements with the judgment, and of course there were protests on the street. So long as those protests are democratic, we cannot have a problem with them. Some of us might agree with the majority's ultimate conclusion, but not with the manner in which it arrived at it. I, for instance, in this talk sought to highlight some of those misgivings. But whatever our views on the judgment might be, there is a logic to it. It considers the facts before it, and it lays down the law as seen by the court. But now you had a review petition that was filed in the Supreme Court. And the Supreme Court, without identifying a single manifest error that was apparent on the face of the record of that judgment, has referred the review petitions to a larger bench to decide on a set of questions that have now been framed by the court, which often have little or no relevance to the list that was in fact before it. Now, ultimately, of course, that larger bench's constitution has to happen. Those review petitions have to be heard. But unfortunately, that case has also been consigned to the back burner. So unless the court clarifies, I mean, this is, in fact, the court is perhaps given itself an opportunity to clarify in the essential practices doctrine. But I would only say that when the court engages with these questions, that it does so by looking at the interplay between individual and group rights predicated on religious autonomy and freedom, because this will have a substantial bearing on a slew of future cases. And one would hope that this principle of anti-exclusion is written into the court's jurisprudence in the years to come, and that would lead to a substantial clarification of the muddled jurisprudence on essential religious practices that is at play today. Thank you. Thanks very much.
Thank you. Thank you, Suhrith.
Thank you, Suhrith.
First, I must confess that I had written some 10 questions to be asked here. But you have answered all those kind of questions in your talk. So I think this is one of the most exhaustive expositions in such a short time which you could have done on this. I will begin by asking a question here. Now, in the preamble, we say that we are a secular country. So what does this word secular mean in the preamble in the context of Article 25? Does it mean that the exclusion of the state from religion, or it attempts at treating all religions equally and respecting the rights within each religion as a fundamental right? How do you see that?
So there's often been an argument made that the word secular, which was inserted into the preamble by constitutional amendment in the 1970s, wasn't a part of the Constitution's text as it originally was. And there have been some people who sought to make this argument that therefore India is not a secular state. But let me sort of try to answer this question at 2 or 3 levels. At the first level, I think these arguments that the insertion of the word secular came only by way of constitutional amendment doesn't carry with it much weight, for the reason that India was secular right from the off-go. The only question was, what was that nature of that secularism? Because ultimately, when we think about secularism, we think about principles of equality and liberty. And those principles of equality, liberty, and fraternity were always in the preamble and sort of animated the entire fundamental rights chapter as a whole. So if we are to say that all religions have to be treated equally and that members of all religious faith have to be treated equally, that proposition really stems from the guarantee contained in Article 14 itself, in the guarantee of equality. There is no need for the mention of the word secular in order for us to come to a conclusion that members of every religious faith have to be treated with equal status and ought to be afforded equal opportunities. But to answer your question on how the use of the word secular affects the interpretation of Article 25, I think in the first place, we need to look at the text of Article 25, because the preamble is not a justiciable provision of the Constitution. You can't go to a court of law and say that the preamble says this and therefore give me this right. So one has to look at the text of Article 25, and the text of Article 25 says that all persons will have an equal right to freely practice, profess, and propagate their religion, and a right to a freedom of conscience. So which means that the rights of one individual cannot be distinguish from the rights of another individual to practice their religious faith. And everyone has to be equally respected and treated with equal concern and regard. But the preamble, of course, can be used as a tool of interpretation, because ultimately it is something that gives meaning to what the Constitution's aim and vision really is and really ought to be. And in that context, I would only say that we cannot see the use of the word secular in the preamble as representing some form of Western secularism. Of course, in the West itself, you have different models of secularism. You have the French model and the American model, which are each quite different from each other. So the question is, what is Indian secularism? And there's been a lot of writing on this. The political scientist Rajiv Bhargava has written quite extensively on what Indian secularism ought to be. And he talks about this concept of a principled distance. That is, because if you look at the text of Article 25, the text itself enjoins the state to interfere in matters of religion. It allows the state to bring about measures of social welfare and reform. It allows the state to throw open Hindu religious institutions to all classes and persons. So therefore, Indian secularism can never be complete distance from religion. It always is a question of give and take in terms of how much and where the state ought to interfere. There will always be circumstances in which the state must interfere. I mean, there are so many social evils that arise out of religion. And I spoke about the Dawoodi Bohra case. There's other practices within the Hindu fold, within the Christian faith, all of which will require the state to interfere. And that interference has to be based on a principled distance, where it's only to bring about equal moral membership. And that's why I think that's where the anti-exclusion principle perhaps helps.
You're muted, Ram.
Sorry. To take off from what you've just ended with, this idea, this anti-exclusion principle, which you just said Justice Chandrachud expounded on, and which others like Gautam Bhatia have written on, has this, since that judgment, animated discussion in law schools, in law associations, so that, hopefully that this would enter the courtroom as well? Or has this been forgotten? I mean, as it seems to have been in the Resham case.
I think it's been, at least at the level of the courts, it's been forgotten. We have Justice Chandrachud's concurring opinion, but we do not have any other exposition on it since then from a court of law. It's interesting, in the Sabarimala judgment, there was also in the main judgment of the 5 judges, there was also a dissenting judgment by Justice Indu Malhotra. And that judgment also says that the essential practices test should no longer exist, and that it should not be the court. So on that, there is sort of a consensus between Justice Chandrachud and Justice Indu Malhotra. But the anti-exclusion principle, I mean, it's at the level of academic debate. There's been a lot of writing about it, as I mentioned, and Justice Chandrachud has adopted, or has certainly used, that academic grounding to lay it down in the form of his judgment. But he himself recognizes that is not the law of the land as it stands today. It's more in the nature of a recommendation to the court, to be something which the court might want to consider in the future, because the law as it stands today is the essential practices doctrine. So one can't entirely fault the Karnataka High Court for looking at that doctrine either. But the only place where I could fault it is in terms of its application even to matters of conscience, as opposed to purely matters of religion.
I asked this question in the context of what Shanta Sen asks on how can group rights actually fit into individual rights. See, as a group, I feel offended that where there is a school dress code imposed on us, some of the people are violating the code by wearing a hijab. So it is offensive to my group right. And so can the individual exercise his right or her right over my group right? That I want law and order and decorum and discipline to be maintained.
Yeah, so which is why I say that the law itself, as much as the government and the court said was facially neutral, wasn't in fact facially neutral, because there are a number of other religious symbols, etc., that have been permitted. Now, I don't in fact think that this is a matter of a group right at all, in the sense that this is not a case of a club, for example, coming together and saying that this will be the dress code within a club. This is the case of a uniform being enforced by an external authority for students, that is the institution for the students. And there's no case of some students, let's say non-Muslim students who do not wear the hijab, to say that the wearing of a hijab offends them. If we go down that route, then the very essence of right to free expression, where we in fact where every individual possesses a right to offend, would be lost. I mean, firstly, this is not offensive. I'm going on on the basis of your question that if people were to claim that this is offensive, which it absolutely cannot be under any circumstances in any case, is to say that there is even otherwise there ought to be a right to offend, and a right to offend is a part of our right to freedom of expression, unless there is some direct threat to public order, or direct incitement or a threat to public order, which there certainly isn't. It's the state's responsibility to maintain public order. I don't think that responsibility can be shifted from the state to the individual. And which is really, to go back to Dr. Ambedkar's idea that the individual is at the core of the Constitution, and that it is from that understanding and from that fundamental sort of philosophical underpinning that these principles of liberty, equality, and fraternity really stem from. If every individual enjoys equal moral membership in society, then that should allow every individual to exercise her free expression and free choice, which would lead to a more fraternal society. And so therefore, all of these concepts are really interlinked. And I don't think group rights are in any manner affected by the use of the hijab by any individual.
Actually, interesting. The one viewer has a point to make in this connection. He says that the uniform should be from the neck down. The face, you should have the right to be distinctive in your appearance. And there, that whether you are wearing a bindi or a hijab or a namam, that should be that should be absolutely fine. You don't not infringing on anybody else's right. Anyway, that's just a comment. Vikram, you?
Yeah, there's a good question there from another friend, Barun. Is there a parallel between the hijab ruling in Karnataka and the increasing restrictions and prohibition on non-vegetarian during Hindu festivals being imposed by certain states and cities?
I think there's a parallel really between almost so many things, right? If you just take the state of Karnataka in terms of the anti-conversion law that was sought to be imposed, and then as he says, the sort of restrictions that are sought to be placed on the sale of non-vegetarian food. There are parallels across the country in terms of I think the general assault on secular freedom. And so this certainly has to be viewed in the larger context. And I was restricted my talk mostly to legal doctrine, because ultimately the courts at any rate ought to be guided by legal doctrine, and this judgment ought to have been guided by legal doctrine in sort of arriving at the conclusions that it did. And I think it is incorrect in the final conclusion that it arrives at. But there are certainly parallels. I don't think you can have restrictions on the sale of food during festivals. I mean, if we go down that path, the list would certainly be endless. There would be no fraternity at all between communities. I don't think, as I said, which is why you cannot claim this as a matter of offense, where your ability to enjoy and partake in matters of your own religion are somehow seen as being affected by what somebody else's choices might be. I think if we go down that route, there will be no pluralism in India. There's no question of living together and fraternity. And the only way to achieve that is by recognizing the equal moral rights of every individual.
There's a question from Smriti Rao, who asks, not specific to this case, do you think harmonization of rights is possible, or should there be a hierarchy? In other words, are certain fundamental rights, should they be seen as more important than the right to religion?
No, I don't. I think harmonization in general is there already, and there is no hierarchy. The fundamental rights chapter doesn't expressly speak about a hierarchy. But Article 25, which speaks about right to religious freedom, does say that the right will be subject to other fundamental rights. It's the only right that's been made subject to other fundamental rights. But as such, the law today, after Puttaswamy's judgment, and we've seen it in a number of other judgments. I mean, we've seen it even before Puttaswamy. It was not nothing novel about Puttaswamy, right from the bank nationalization case onwards, which is that these rights cannot be seen as independent silos. If we go back to the earliest constitutional case before the Supreme Court in A.K. Gopalan versus State of Madras, the reason why the preventive detention law at the time was upheld was that the Supreme Court saw these rights as each being part of their own separate compartments. So if a right under Article 21 was claimed to have been violated, the court almost saw that it could not also be a case under Article 19. So, and that led, I think, to a rather anomalous situation where a draconian law wound up being upheld, because the court believed that it was offering a very textual interpretation of the Constitution. But now, especially post Puttaswamy, all these rights have to be seen as a collective whole, and they really give and take meaning from each other. So there are other constitutions where this is more explicit. If we look at the Canadian Constitution, a number of rights are laid down, and then there are no specific restrictions given for each right. Instead, you have one general restriction on which the state can limit rights. So, I mean, perhaps to adopt such an interpretation might not be in consonance with the text of the Indian Constitution. But nonetheless, when we see these rights as not being part of separate silos, but as being one collective sort of union, then it'll lead to a case where there is no hierarchy, but rather a harmonization, as the person asking the question says, where the rights are not militating against each other, but where every right is. There might, of course, be cases where there is a clash between the right of one individual and the right of another individual. In such a case, the court will have to balance it on the basis of the use of the principle of proportionality and see how both rights can be preserved to the greatest extent possible. But as such, otherwise, as a matter of theory in abstract, what one would have to say is that these rights will have to give and take meaning from each other, and there is no hierarchy between the rights.
See, when the Hindu Code was amended in 1948 and 50, I don't remember, there were significant departures from cultural practices when it was codified, right? And then we did not question whether these practices were essential to the practice of the religion. So how do you see that now?
So, which is why I said the Constitution, if you look at Article 25, it talks about social welfare and reform as an exception to the right to freedom of religion. So, Article 25(2) says, nothing in this article, and 25(1) is what guarantees the right to practice religion. 25(2) says, nothing in this article will affect any law which, among other things, in 25(2)(b), which provides for social welfare and reform. So the moment a measure is for social welfare and reform, then the state is allowed to restrict the right to freedom of religion, even if that practice is essential to the faith of the proponents. But of course, the countervailing factor is that any such restriction will have to be proportionate. It need not erase the fundamental right as a whole, but you'll have to balance it and see if the state has chosen the least intrusive measure available. I mean, we've had a number of practices prohibited over the years. For example, sati is seen as it might have been seen as a cultural or religious practice, but it's been prohibited because the government has the power to bring about social welfare and reform. Which is why I said one of the regrettable, there have been some regrettable judgments on this. For example, the case concerning in Sardar Saifuddin concerning the practice of excommunication. So when a member is allowed to be excommunicated from a religion by the leader of a religious group based on apparently an exercise of a group right, then I think it leads to a case, because in certain religions, if you are excommunicated, it virtually leads to a complete erasure of your civil rights. You are treated as a nobody. Your identity is completely erased. So then it becomes necessary to uphold those laws which provide for social welfare or reform.
Suhrith, there's a question from Gopal Tadepalli. I'm not sure I can grasp the question, but let me pose it to you. He asks, does one willfully quote secularism in quotes in a discerning community with the secular quote as a degree of safety? Is he suggesting that we are using secularism as an excuse? I leave it to you. If you could discern the question as such.
Yeah, I think what he's trying to get at is that, do we take it, or do we continue to try and strive for secularism in the belief that the courts will come to come to save us if we do it? I think we don't have much.
Perhaps that is, yeah.
I would think we don't have much of a choice, right? Our constitution requires us to be secular. We have a constitution that guarantees, as I said, a right to equality. And ultimately, we should strive as a society to uphold these values. And the courts play an integral role in upholding those values. Not just the courts, Parliament, the state legislatures, the executive, all bodies of government play an integral role in upholding these values.
Right.
And when those values are not upheld by people in power, by the governments of the day, whether it's by Parliament or by the state legislatures or by different executive governments, then the courts will have to act as a check against those excesses. And which is why the court is effectively viewed as a counter-majoritarian institution, which will protect the rights of people, regardless of what the majoritarian impulses of the day might be. And that's sort of the most important role that the court will have to play.
Very simple question, Suhrith. We have just promoted you to the possibility of being a judge in the Supreme Court. But the question which follows is, if you be the judge of Supreme Court, will you allow women to Sabarimala?
Yeah, of course. I've already said so during the talk, which is on an application of the anti-exclusion principle. There's no question of excluding any person, I think, from the precincts of a temple. I think individual dignity and equality need to come above any claim, and certainly above claims made by groups. And I've also argued elsewhere that I don't think the temple in Sabarimala has a claim to make in terms of being a religious denomination. I think it's a Hindu temple which is open to all classes and sections of people. And once it's a public temple having the character of a public temple, there simply is no question of excluding any person from the precincts of that temple. And I think to practice that exclusion leads to a violation of individual rights. And it's to my mind not a very hard case to answer.
Suhrith, something different to take off from what you had fleetingly mentioned earlier. And I'm intrigued by this anti-exclusion principle, which to me seems a useful principle to clear the mess in a number of areas. Now, you talked about clubs as private bodies enforcing dress codes, but as a private body, we know that many housing societies are excluding people from certain communities, certain religions, and that is increasing. If I'm not mistaken, this started with some building society in Bombay.
The Zoroastrian.
Zoroastrian. can't the same anti-exclusion principle be applied? And not only that, doesn't this infringe on the right to life, right to housing, that you're keeping out, you're denying a person shelter only because of his or her religion or cultural practices?
I think you're absolutely correct. The regrettable thing is that the Supreme Court held in the Zoroastrian Cooperative Housing Society's case that Article 15 will not apply to private housing societies, and therefore that these kind of exclusions can be made. But if we were to look at Article 15.2 for a moment and look at the text of the Constitution, 15.2 says, no citizen shall on grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or condition with regard to A, access to shops, public restaurants, hotels, and places of public entertainment, or B, the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So 15.2 is a right that is enforceable against fellow citizens, against fellow private groups. It's not a right that is enforceable against the state. It's a fundamental right that is enforceable even against private citizens. So if a housing society were to exclude people from their confines, then I think it's directly hit by 15.2a. A number of people have made this argument before. Access to housing is not very different from access to shops. I mean, shops is the term used in 15.2a, but it's a term that requires wide interpretation. I mean, so access to any civil goods, the civil right to access any goods, any basic goods, will have to be treated as fundamental. And housing would certainly be a basic good. I mean, we have, in terms of the use of the words basic goods from Rawls onwards, you would think that housing is a basic good. And if the right to housing is restricted in this manner, then there will certainly be problems. So I don't think you can have conditions where people do not offer a lease to certain members of certain gender or to members of certain religious faiths or caste-based discrimination on that. That would certainly be hit by 15.2 and perhaps even by Article 17.
Ram, if you don't, I will ask the last question. Okay. And then you can close it. This is the first question which has been posted in the chat box. So I think the influence of the political environment has not been touched upon. Why?
Yeah, because I don't. It's been something that's run. It's something that's run through the thread of the talk, certainly, without being explicit, for the reason that the talk itself was on the abstract doctrine, as I said, and on the court, as opposed to the political sort of leaders and government of the day, because some of these problems have been present throughout the history of our country. If you look at anti-conversion laws which have been enforced by various states, this is not the first time that we're seeing some of these anti-conversion laws that have been enforced. And you have judgments of the Supreme Court that go back many years where those laws were upheld. For example, in Reverend Stanislaus's case, and I've written about it in the India Forum, which is a judgment which H.M. Seervai described as being productive of great public mischief. But as I said in the answer to one of the other questions, the ban on the hijab is not an isolated incident. It is certainly something that flows from the majoritarian impulses of the day. There have been more and more laws that have come up across the country which have sought to militate against the vision of secularism that we are used to, that our constitution puts in place. Whether it is this ban on hijabs or whether it's the increasing proliferation of anti-conversion laws, the bans on beef, bans on, as somebody else said, on the sale of non-vegetarian food. The list really is endless. So this is where I think the courts will have to introspect and try and examine what their role under the constitution is. Ultimately, the court in India's democratic structure has to act as an institutional guardrail against majoritarian excesses. And when we live in times where those majoritarian excesses are especially troubling, you would hope that the courts step up to the mark and come down heavily on these majoritarian excesses by performing its sort of true role under the constitution, by acting as a balance and as a check against the political powers of the day. And by looking at the constitution as a document that is sacrosanct, as something that will have to be placed above. Ultimately, democracy properly understood is not just ruled by numbers. It has a number of other facets to it, including the provision of various fundamental rights that are guaranteed in the constitution. And therefore, I think any influence that the political environment of the time has played in bringing about these laws will have to be checked by the judiciary. And one hopes that it's checked in the years and in the days and years to come.
Yeah.
Yeah, thank you, Suhrith. It has been a wonderful talk, cogent and clear as your writings, explaining not just the judgment, but the larger issues involved, principles involved. And for me personally, this whole idea of, as you can see, the anti-exclusion principle is buzzing in my head. And I hope that this would enter public discourse and take it forward. Thank you very, very much for giving us time, speaking, and I hope you will come back soon and perhaps even in person in Hyderabad to talk. We would just like to announce that the next Manthan event is an in-person event. It's on March 6th at Vidyaranya School.
May 6th.
Yeah. May 6th, sorry, May 6th, not March 6th. It's by S. Rukmini, and she will talk about data and democracy. And we're also trying to organize a talk from Sri Lanka, on Sri Lanka. And if we do, we will announce that, of course, will be an online event. So until then, thank you all. And thank you once again, Suhrith, for spending time and talking about this issue.
Thank you, Suhrith. That's been a very engaging and a cogent talk. Thank you very much for that.
Thank you, Mathesh.
And welcome to come. Please do come back to Manthan in person.
Thank you, sir. Thank you.